Will a Texas federal judge halt the increase to the minimum exempt salary level that's supposed to go up on January 1st in the U.S.? If he does halt it, will that take effect nationwide, so it will affect all employers? What about the increase that already took effect July 1st? Or in other words, I listened to a federal court hearing for 2.5 hours, and I'll break it down, so you don't have to. So to back up, I've made some videos on this, but in short, in the U.S., to be classified as exempt, meaning paid a set salary and not eligible for overtime no matter how many hours you work, you have to meet, generally for most roles, 2 tests, and you have to meet both of them. A duties test, so what you do, and there's different duties tests for different classifications, but then also a salary test, so a minimum of that. And I'll be talking about the salary test because the duties test hasn't been impacted now and hasn't in recent times. Now, there are some exemptions to that salary test, like the outside salesperson. Certain categories of professionals, including lawyers, doctors, and teachers, don't have a minimum salary. Does it apply to nonprofits? I get that question. It can depend on the commercial activities of nonprofits. But for most exempt employees in the U.S. that are classified, this minimum salary has gone up from time to time, and how that happens is that the U.S. Department of Labor, ever since the Fair Labor Standards Act, which was the act by Congress passed almost 100 years ago, gave all the exempt and non-exempt, it doesn't mention in that a salary test. But the U.S. Department of Labor, as a federal agency, gets to issue kind of rules to define it further. That's how a lot of these laws and agencies work. Ever since the FLSA was passed, the Department of Labor, so again for almost 100 years, has used this salary and duties test. But so what happens is from time to time, the salary level goes up. So that happened in 2004, went to $23,660. It went up again in 2019 to about $35,600. The U.S. Department of Labor had tried to have it go up in 2016 under President Obama to like a bigger number, like $47,000. That got stricken down by a court. So if it feels like deja vu, that's what's happened in 2024. So in April, the U.S. Department of Labor introduced a rule. So there would be 3 key things. One is that on July 1st of this year, which happened for all but one employer, that minimum salary level went up from about $35,600 to about $44,000. It's then scheduled to go up again on January 1st to about $59,000, so a big jump. And then every 3 years thereafter, there's scheduled to be an automatic increase based on economic data. So that's for the first time, because now there hasn't been that automatic increase. So what happens from time to time, and has happened historically, is that when these increases, these rules are put out by the Department of Labor, there are groups that challenge them. So there are 3 active lawsuits in federal court right now challenging this rule, which again is a little awkward because on July 1st, it took effect. And as I mentioned, it's all but one employer. Because in one case, which is a case, it was the state of Texas as a government employer, the federal judge there, Sean Jordan in Texas, he'd halted this from taking effect. He issued a preliminary injunction. So that July 1st increase didn't take effect, nor would the January 1st and the every 3-year increase. So that was just for the state of Texas. And when he issued the preliminary injunction, he said that overall this rule was likely illegal, but he was only halting it for the state of Texas because the state of Texas hadn't given any evidence of how it would harm anybody else across the U.S. So it's applied to these, employers. But so scheduled to go on January 1st, now these 3 cases, so the state of Texas case, which is still going, because the judge there now, the same judge, Judge Jordan, is deciding whether to halt it potentially across the board for all employers, to issue a permanent injunction. And the 2 other cases, one is in D.C., another is in Texas, those 2 cases are also before judges. Now, why I'm talking about the state of Texas case is because there was a hearing today in federal court. And there were 3 lawyers, or 3 parties making arguments. One party had 2 lawyers, but one was the state of Texas, so they had lawyers arguing for it. And in those, they make statements, and then the judge gets to and does ask them questions. There are also business groups. So now all of these business groups, like trade associations, like the National Restaurant Association, manufacturing organizations, all of that have all joined on to say, hey, this should be halted. These increases should be halted. These are illegal. The Department of Labor does not have the legal authority. Only Congress can actually do this. The other group that argued was the actual Department of Labor. It was a lawyer from the Department of Justice, who, as an aside, was, I believe, 33 years old. And at 33 years old, I was nervous to get ready for one-on-ones with my boss. I was a lawyer, I don't think I could have been making this argument, certainly not taking all the questions. Because here, so this judge already has issued, again, this opinion, halting it for the state of Texas, saying that overall this is likely illegal. So yes, the Department of Justice and these business groups, they had their statements. The vast majority of the hearing was the lawyer for the Department of Justice or Department of Labor getting all of these questions from the judge about whether this is actually legal. Now, lawyers will tell you, because as I listened to this, my thoughts were like, oh my God, she's really taking these punches. But lawyers will tell you, you can't always read into that. Because often when you walk out of a hearing, if you feel great about it, you don't always get a favorable ruling. Sometimes you can be surprised. Now, whatever reason that is, as I took away from it, trying to figure out what's going to happen. Because now what the judge could do is halt it altogether and issue a permanent injunction saying, not only does the January 1st, is that not taking effect in the every 3-year increase, but also the July 1st impact that's already taken effect, that's not either. So then employers would have to decide whether you roll that back internally if you've increased salaries, or whether you reclassify employees as exempt. So they would have to figure that out. But the one thing that I thought notable is in his ruling previously, the judge again had halted and said that all 3 were illegal. Now, there's a large part of me that believes that, having listened to this and read his opinion and pretty much all the filings in this case, that the judge will do that. There's a part of me that does expect that he'll say that all 3 aspects of this are legal. But as I think about it and kept reading through, I actually could also foresee the judge keeping the July 1st increase, keeping that intact, so that already applies to employers, leaving that intact. Then it would start to apply for the state of Texas as well. And the reason I say that is because the judge did talk about 2 cases in particular in this hearing today. One was Loper Bright. And this is actually one of the very few Supreme Court cases people are like, what about Loper Bright and Chevron? So Chevron was an older Supreme Court case that had said that federal agencies like the Department of Labor, they get a certain amount of deference because this is what they do. So if they have a rule, there's a presumption that it's okay unless a judge finds otherwise. Loper Bright, and that's paraphrasing it, Loper Bright undid that. And so it doesn't mean, like some people think, it didn't say an agency can't issue a rule. It just says that if it's being challenged in court, the court has to look at that with fresh eyes. So they don't give it the level of deference that previously had under Chevron. So they did talk about that. And the Department of Labor brought this up as a positive, and I honestly am not sure why they did that, because the state of Texas and business groups were like, Loper Bright certainly does not favor the government, and it really does. It, to my opinion, does not. But the one case that they did bring up is a case called Mayfield, and that's been decided since the judge issued his preliminary injunction, halting all 3 of these steps for Texas. And that was a 5th Circuit Court of Appeals case, and that the Court of Appeals is the appeal level above the Texas District Court. So it's Texas District Court, Court of Appeals, here 5th Circuit, then the U.S. Supreme Court. And that was a Texas case actually challenging the 2019 increase that was done under former President Trump's Department of Labor. And there, Mayfield was a Dairy Queen franchisee that's actually challenging altogether whether there can be a salary test under the Department of Labor. And the Texas federal court had said, yeah, there can. The 5th Circuit Court of Appeals agreed and said, yes, there can be a salary level test. But the 5th Circuit did say, it can't be a substitution, or it can't replace the duties test. The duties test still has to matter. So why I think that can matter here is the judge talked about the Mayfield. And again, the Mayfield definitely is a bit favorable for the Department of Labor, saying there can be this test. The question is, and Mayfield did not decide, what are those limits? And so why I actually think that July 1st could be upheld, and again, we'll see, but because he already had stricken it down, but the July 1st used the same methodology that the Department of Labor has used since 2004. There, they looked at the 20th percentile of the lowest earning region in the U.S., which is the South, where I live, and that's what they use. And so consistently, they use that same approach that they used since 2004 for July 1st, 2001. And the federal judge had looked a lot at that there were 1 million people that on July 1st, 1 million people that were no longer met the exempt salary level. And so 1 million people were affected. And the judge described it as employees losing their exempt status. So now they were non-exempt. And so a lot of times I have people that ask, what are the benefits to being exempt? And sometimes companies have different PTO, paid time off if you're exempt or non-exempt. But otherwise, there can be some benefits to being eligible for overtime. It depends in part whether your employer is do you have to work less hours? Or are you working the same and your employer just reduces you to a pretty low hourly wage? So the judge talks a lot about what a benefit it is to employees to be exempt. And so it's probably another topic for another video. But the one reason is I go through things that could potentially see the judge upholding the July 1st increase was that it uses the same methodology. Sure, 1 million more people are non-exempt, but as the Department of Labor pointed out, that's going to happen anytime and that happened in 2004, 2019, anytime you raise that limit, you're going to have employees affected that either have to have their salaries raised and remain exempt or to be reclassified as non-exempt. Why I personally expect the January 1st and then the triennial increase to be struck down is that the methodology changes entirely. So January 1st, why that's such a big jump, is the Department of Labor switched from what they've done for the last 20 years and use this 20th percentile and go increase it to like the 35th percentile. And so the judge focused 3 million more people on January 1st, according to the Department of Labor data, would have to be either reclassified or have their salaries increased. And then every 3 years thereafter, the numbers, they have them. It's every year, either 4 to 6 million people are impacted as the increase goes up. And so I personally expect, as the judge has really leaned on, salary cannot replace the duties test. And when you have so many people that would be reclassified, I'd expect the judge to lean on that with very similar reasoning to his ruling on the preliminary injunction in the state of Texas to halt that. But again, there's this part of me that can see him keeping the July 1st intact. So for those employees watching, this is just my personal read of it. Again, I don't practice law, but it's just hopefully important to break it down and report what you see. Again, there are 2 other cases. So what's happening in those? The DC case is literally fully briefed, so technically it could be any day. And I'd mentioned in a video previously of and this was brought up a little bit, that there are other cases. And so I don't know whether there's a judge code that the DC judge, for example, wouldn't issue an opinion before this Texas judge. But as I mentioned, there is another Texas case, Flint Avenue. There, the judge, just a week or so ago, has said that they actually invited additional briefing on Mayfield, even though the parties have actually already talked about it in the brief, but the parties have another week or so to add any additional briefing on that case. And so the judge kind of punted out a little bit, so there wouldn't be a decision on that coming soon. So I mentioned, so this judge had a hearing on the preliminary injunction. He had taken 4 business days to issue a written decision halting the rule. So the judge did not, at the end of this, indicate how he was going to rule. One thing is, repeatedly in it, the lawyer for the Department of Justice had offered to issue supplemental briefing on some of these technicality, because they got super into the nitty-gritty of different tests that have been used and data and percentiles over the last 100 years. And the lawyer kept offering from the Department of Labor to give supplemental briefing, basically, well, we can say more, we can give you filings. And the judge finally had said, I don't anticipate that's necessary. So this judge will be issuing a written opinion. Personally, I'd expect that in the next week or two, because we are going to be coming up on that January 1st deadline. But we'll see. Again, from preceding history, he'd already said that all 3 were likely illegal, but I could see the July 1st staying intact. But I personally would expect the January 1st and the increases after that to get halted. So we will see. But a lot of those, you're seeing news articles of salaries are all going up. And so employers certainly have to be modeling and figuring things out. But those employees that are counting on an increase to their pay January 1st, I just think people need to be mindful and watch what's coming out, because especially after today's hearing, I wouldn't say that is an absolute necessary to happen or guaranteed to happen. And one additional question, how does the election impact this? Because right now, the Department of Labor is under President Biden's administration, but January 20th, it will be under President Trump's administration. But January 1st is between now and then. Well, you can look to history. So this is very similar to what happened in 2016, when President Obama's Department of Labor had issued this proposed rule. A federal judge had actually stricken it down, so this is what will happen if the judge strikes it down here, had issued a nationwide injunction. And then when President Trump took effect the next January, his Department of Labor, over time, they basically halted the appeals and had the compromise, which led to the 2019 increase. That went up to 35,600. As opposed to the 47,000 that had been proposed by President Obama's administration. So what could happen here is if this judge or either the other judges issue a nationwide injunction, then it will be halted until it goes through the whole appeals process. And as I've mentioned before, regardless of everything with the election, with the current makeup of ultimately the U.S. Supreme Court, most legal people looking at this do not expect these increases to survive if they're halted and then appealed in court because of the makeup right now of the Supreme Court. But with the election, if it's halted, then again, what could happen is that when President Trump takes office, his Department of Labor, his Department of Justice, they could do very similarly. And they could either basically kind of end the appeals and not try to protest and just let it be halted, and either issue a compromise increase to the salary or just not do anything at all. So that's kind of what could happen. If it does take effect on January 1st, then yes, when President Trump takes effect on January 20th, still his Department of Labor could issue a rule to go back and decrease that. But what that means is there'd have to be a whole nother rulemaking period, notice and comment, which is opportunities for the public to comment, all of these things. And so they're also, can certainly appeal in court. But with the makeup of the Supreme Court, if it does take effect January 1st, I personally don't know that I'd expect this to be one of the top priorities to reduce that level down. But again, I personally expect on January 1st that 59,000 roughly increase it's going up to. I do not expect that to take effect. And so then I also would not expect President Trump's administration, just based on history, to push in court to appeal that, or for the Supreme Court ultimately to be like, yeah, that should happen. And so that's why overall, I personally don't expect that January 1st increase to take effect. And I know this video is longer, but that's why I have timestamps, and it's hard to break down a 2.5-hour hearing, kind of the history on it, in less time than this. But if TLDR, I personally don't expect the January 1st to take effect, and I'm totally equally split in my mind about what will happen with the July 1st increase that's already taken effect.